Hi, we'll start immediately. Apologies for starting behind schedule. Um, so, for today, we are going to continue from where we stopped last class. That was yesterday, and that would mean that after I've introduced you guys to the core tenets of corporate governance, and we looked at how corporate governance architecture looks like. So today we are now going to take it a step further by looking at what I may call organs of corporate administration. So we're going to look at what we call organs of corporate administration, organs of corporate administration, or we may call. So the idea, as I noted yesterday, basically is to say that for a company lives out its corporate personality through the agency of human beings. So, which means that it is some persons that take decisions, they make decisions as the company. So, when a company does something, it means that there is a person or there is a group of people that have the authority to act as the company. So the administration of company or the governance of the company in terms of decisions the companies would make, in terms of strategies, in terms of the policies, in terms of the processes of the company, there are human beings that are behind all this. And I already noted it in yesterday's class that on the one hand, we have the members in general meeting. On the other hand, we have the board of directors. And I also already rationalized, I gave you reasons why these two bodies are meant to be organs of the company. And we also looked at it further on the board side, looking at the two-tiered board system, the supervisory board, the executive board, and I also was able to conceptualize to you guys what the roles and responsibilities of these two groups within the board system. And we also looked at the roles of our committees when it comes to the corporate governance architecture of a company. Now, today we want to now look more into what we describe as organs of corporate administration. And what we find in today's class is that it is more of a consolidation of yesterday's class. But we'll now deal more with specific in terms of some of the provisions of CAMA 2020. So when we speak of organs of corporate administration, the idea is that we want to, having, by at least with what I said yesterday and the fact that I've also repeated it today, by now you should know that when we speak of a company and we say it's an artificial entity, yes, but to feel the impact of a company, you need certain human beings. But it's not everybody within the company that can act as the company. It's not the action of everybody in the company that can be taken as the action of the company. It's not every step, every decision taken by any person that is associated with the company that the company can be held liable for or the company can take benefit of as its own words action. So we want to now know who are the core decision making organs in the company. That is, who are those that when they breathe, the company, when they breathe in a particular manner prescribed by the law, you can say it is the company that has actually well breathed. And those persons, we want to know them. So the first thing I will bring to your attention is that for the organs of the company, we have those that we may refer to as the primary organs. The primary organs, and we also have those that we may refer to as the secondary organs. Now, the idea of organs of corporate administration, we are looking at who are those in the company whose actions affect the company, whether positively or adversely. That is, those people that when they do something, it affects the company because it is taken that it is a company that has done it. Now, let us leave out company because as an artificial entity, it may be difficult for you to quickly comprehend what I'm saying. So let's assume it's a human being. So let's take Salama, for example. Salama, as a human being, right, you know that you are responsible for your actions. So which means that you can do things either by yourself, and whatever it is that you do by yourself, whether it brings about good outcomes or negative outcomes. The idea is that you did it by yourself. So whatever it is that you have done by yourself, it is your action and it is your inaction, it is your omission. But the thing is that you, Salama, you don't have to do everything by yourself. So you could act by yourself, yes, no doubt. But you don't have to do everything by yourself. And what I'm trying to point out is that it is also possible that you, Salama, when you want to do something, you are the one that you want to do that thing. Oh. You can do it through the agency of another person. So which means you can ask somebody to act on your behalf in such a way that you are ready to take responsibility for whatever it is that that person has done since you instructed that person to do it. So essentially, when you want to act as a human being, you are either acting by yourself personally or you are acting for yourself but through another person. Now, that is the same thing with a company. So, when we are speaking of organs of corporate administration, the idea is we want to look at how companies act. Now, companies can actually act by itself or by themselves. That is, a company can act by itself, and it is the same way Salama could have also acted by her own self. A company can also act as the company. Then it is also possible that the company is also acting through the agency of another person. So the company is not acting by itself. Instead, the company is acting through another person. So either way, the company is acting either by itself or through another person. Now, for this particular topic, these organs of corporate administration, one of the behavioral objectives or the learning outcomes is that you students should be able to identify how a company can act as the company. That is, the company is acting by itself. Yeah, even though it's an artificial entity. And also for you to also be able to determine cases or circumstances where the company is acting through another person. That is, the company is not acting by itself, but instead the company has asked another person to act for what? For the company. So the action of that person would be attributed to the company. So what I'm saying is, you know, it is more or less saying that the same way you treat a human being, you should treat a company that's same manner, at least to a very large extent. So if a human being can act by himself or by herself, or appoint somebody to do something and then for their own benefit, a company can also do so. So there are two questions to ask at this juncture. And the first question is, given that a company can only act through human beings, that is, when we say a company has done something, whether by itself or through someone, it must involve what? A human person or a group of persons. So the question now is, the first question is, how can a company act for itself? That is, in what circumstances can we say the company has acted as the company? The company has acted directly. The company did not require somebody to act on its behalf. It acted by itself. And in what circumstances can we now say that the company has also acted, but through another person? So what that person has done is only being ascribed towards the company. These should be the two questions that should bother your mind more. Now, and to answer these two questions, all you have to do is to appreciate what I've stated on the board, which is that for the organs of corporate administration, organs, the decision makers of the company, right? Yeah, those that make decisions, those that when they move, then the company has moved. We have the primary organs on the one hand, and we have the secondary organ. So when we speak of the primary organs of the company basically refer to those group of persons that when they act in the manner prescribed by the law, it is taken that it is the company that has acted. Now, remember, I said there are two ways a company can act, just like a human being. The company is either acting personally by itself, or the company is what? Acting through another person that it has authorized to act on its behalf. So when it comes to identifying circumstances where a company has acted by itself, that is when those that are the primary organs, when the primary organs act, any action that is taken by the primary organ in line with the prescription of the law. Now, please, yesterday and even today, I kept emphasizing that it's not enough to identify the body or the group of persons whose actions can be taken as the action of the company or attributed to the company. I said you must always say it is when they have acted in accordance with the law. And the law here refers to either the substantive law, such as KAMA, or if it is a company that trades in a regulated industry. So any other law or other laws that are prescribed by the regulators or even by the legislature to regulate that company are part of the laws. Aside that, the company's constitutive document. So when we are speaking of the law here, we're also talking about the company's constitution, the memorandum of association, the articles of association, because there are times that the articles may also prescribe how these organs are meant to conduct their affairs, their business. So if they do not comply with it, then they have not acted as the company or acted on behalf of the company. So that is one thing to know. So when we speak of the primary organ, see it as the body that acts as the what? As the company. This body acts as the company. But when we speak of the secondary organ, we are talking about those that act on behalf of the company. Those that act what? On behalf of the company. These people are not acting as the company. They are acting on behalf of the company. So now, what is the implication? What was the implication in distinguishing the primary organs and the secondary organs, particularly for a third party, anyone that is dealing with the company? You need to know who you are dealing with. Are you dealing with the primary organ of the company, or you are dealing with the secondary organ of the company? It is very important. And why is that so? One of the reasons is that, see, for your primary organs, the primary organs are those bodies that act as the company. So when you deal with the primary organs of the company, it is as though you were dealing with the company directly. So if, for example, I want to buy something from Salama, and I walk up to Salama herself, and we discussed, we negotiated, and then there was an agreement to render this service or so or thereabout. She is the owner of the business, and I've dealt directly with her. Yeah, that is Salama as the company or as the primary the primary organ. But you see, for the secondary organ, this secondary organ here, they are not acting as the company. No, it is not the company that, when you deal with the secondary organ, you are not dealing with the company directly. You are dealing with the company indirectly. What does that mean? It means that you are dealing with somebody that has been authorized by the company to act on behalf of the company. So this is not a case where you walk up to Salama and deal with Salama. Maybe you are not dealing with the branch manager or the sales manager that works for Salama, that Salama has now authorized that, oh, go ahead and do. So you are not dealing directly with Salama. You are dealing with this person because you believe that this person has the authority of Salama. So the issue there is that when you are dealing with Salama, if there is any issue, you can sue Salama directly because you dealt with Salama. But this time around, when you are dealing with, say, the branch manager, so let's say Onye is the branch manager. Now you are assuming, or of course you might also confirm, that Onye has been authorized by what? By Salama. So you know that at the end of the day, even though you are dealing with what? Onye is acting as a representative of Salama. So it's almost as if you are acting for Salama. That is where the law of what? The law of agency. He will act through what? Another act for himself. If Salama is acting through Onye, then Salama is acting for herself. So, but the problem is that in your law of agency, before the principal can be held liable, the agent must have been authorized, or the agent must have acted within the boundaries of his or her authority, except where the principal decides to ratify circumstances where the agent has acted without authority or has exceeded the authority that has been conferred to. So it means when you are dealing with Onye, right, as a representative of Salama, you are now being hopeful that Onye has the authority, or the extent to which you are dealing with Onye was actually given that authority by Salama. Because it is possible that you will deal with Onye and there will be a problem. And then you will sue Salama that, well, even though I was dealing with Onye, it is almost as if I was dealing with you because you were acting through Onye, only for you to realize that Onye does not have the authority. So that way you can't hold Salama liable. You are probably thinking of holding what Onye was liable. So the idea is that for the secondary organs of the company, the way to hold the company liable is to use the two methods of attribution. There is the doctrine of attribution. And the idea of doctrine of attribution is to say that you can attribute the action of one person to the other person. What does that mean? Some A will do something, but B will be the one to suffer it. Why? Because B was the one that authorized what A to do it, or B was the one that put A in a position where A could do what could do that particular thing. So nobody is suing A, they are actually suing B for the action of what A. If B wants to say this is unfair, the law responds to B and says it is fair. Because even though you have not done it, it is another person that did it. But what that person did is almost as if what you were the one that did it. You acted through that person. So you are the one that will be held what? Liable. So for the secondary organ, it means that when you want to hold the company liable, you are looking like at what? Things like what is it called? Before you can hold that company liable, you are looking at things like, say, um you're looking at concepts like what? Agency. Yes, your law of agency is one of the application of the doctrine of attribution. Yes, because in an agency relationship, the action of the agent is attributed to the principal. That is the reason where there are any benefits from whatever transaction or contract or land disposition that the agent has involved himself in. It is for the benefit of the principal, not even the agent. Such when there is also what any liability, any loss or harm is also the principal. So what is being done is that you are attributing the action of the agent to the principal. Then another another doctrine of what attribution is what we call vicarious liability. Vicarious what? Liability. And by in your 300 level, when you did your law of thoughts, you were taught vicarious liability, which is basically to say that, well, if there is an employment relationship, when the employee has is acting for the what for the employer, so there is an employment relationship, and the employee has done something in the course of what in the course of his duty as an employee. So if he has breached what a law, the employer can be held liable, because the employer is assumed, or it is supposed that the employer has a deeper pocket. Yes, not that you can't sue the employee, but you know that the employee may not be in a position to be able to compensate you. That is why you are suing the employer, that, well, this person was acting for you as your employee in the course of his duty, in the course of his responsibility. So you see, in this case, it's not necessarily the employer that has done the harm or the act. It is the employee, but the law attributes the action of the employee to that of what? The employer. So the problem is that if you have dealt with the employer directly, you just sue the employer. And then it probably is easy for you to just say, my lord, we dealt with this person, and then this person has breached what? So thought or so or thereabout. But when in this case, it is the employee you dealt with, but you want to hold the employer liable. You have to pass the order of showing that, oh, there is an employment relationship between the person that you want to hold liable and the person that did that act. You might not be able to prove that. Or even if you're able to prove that there is an employment relationship, you might also have to prove that, oh, this person did whatever he did in the course of what? In the course of his employment. You might be facing these challenges. That is why it is better to deal directly with that person, because you don't have to now start showing the court why the law should attribute the action of A to what? To B. So what I also translate into is that when you are dealing with these people that will form part of the secondary organs, and then you want to hold the company liable because you believe that they have acted on behalf of the company, you are either doing it through agency or you are doing it through what? Vicarious liability. And then you have to start proving all the elements of agency if you are going through the route of agency, or the element of vicarious liability if you are going through the route of what? Vicarious liability, because you have dealt with the secondary organs of the company. But if you have dealt with the primary organs of the primary organs of the company are the company. Yes, they are human beings, but when they act in particular circumstances as prescribed by the law, they are not acting for themselves. They are acting as the company. So when we are speaking of the company, we are necessarily talking about the primary organs. So when you want to be sure that, oh, the company has done something. Aha. You ensure that, oh, it is whatever it is that these primary organs will do. But if it's not the primary organs, maybe you are dealing with what, the secondary organs. In the secondary organs, you have to prove that whoever it is that has that have acted here, that this person has what, authority of the company. So who is now the company here? Don't see the company as an artificial entity anymore. Yes, in first semester, looking at corporate personality, you might see the company as artificial entity. Now the company is a group of persons. That is just it. That is the reason why those that argue that the contractarian school of thought will tell you that a company is nothing but what, a vessel that is used to bring together a collection of rights of different people. So at the end of the day, it's still human beings that are necessarily what the company, but it's not all the human beings. It's not every person involved in the company. It's just what, a selected what, group of persons. And it is only when they act in some particular manner that you cannot take their action as the company. So it is possible for people or a group of persons to act as the company. And it is possible for a person or a group of persons to act on behalf of the company. They are two different things. They are two what? Different things. So the primary organs act as the company, while the secondary organs would act on behalf of the company, which means they must have authority. These primary organs need no authority from the company, because this is actually the company. All they have to do is to what? To comply with the law. They are already the company. All they have to do is to just comply with the law. But you see the secondary organs, this is not the company. This is someone that is authorized by the company, because the company does not have to do everything by itself. So which means that for the secondary organ, you have to prove what? That they have the authority of the company. And who is the company? The primary organs. So if the primary organs are the company, then it means that before the secondary organs can what? Can act, and for the company to be held liable, they must have the authority of the primary organs, or it must be that what? There is vicarious liability. Is what I've said, do you understand it so far, please? All right. So that is that. So now the question to now ask is basically to say, who are the primary organs? Because these primary organs are the company when they act in accordance with the law. So who are the primary organs? Who are those that act as the company? Yesterday, when we look at the corporate governance architecture, I already told you guys who the primary organs are. I said there are two main bodies. There are two main bodies that are considered to be the company. Their actions are taken as the action of the company. Not that they are acting on behalf of the company. There is a need for me to keep emphasizing this. They are not acting on behalf of the company. They have acted, or they act as the company. So when you deal with them, anything that they do in accordance with the law, in circumstances where the law says, oh, when they do this thing, is the company that has what, that has done it, then it means that what, you are dealing with the company directly. So what we are saying is, say for example, the rule that says the rule in First Anabo 2, the majority rule and minority protection, that says that when a company has been harmed, only the company can decide to sue to remedy that harm. That is, the company is a proper plaintiff in an action where there is a corporate wrong. And that is the rule in First Anabo 2, and is now in section 341. Now, the word used by the act is the company. So it says it's the company that must take the decision whether to approach the court or not, to what? To sue. So the question now is, when you say it is the company that must take that decision, the primary organs are the company. So when the law says the company is the one that must take that decision, it means that the law is saying that it should be either the members in general meeting or the board of directors, because these two bodies are the ones that constitute the primary organs. So anywhere you see in the act that it says company must do something, company is the one to do something, then it's basically saying that that decision is to be taken either by a resolution passed at the general meeting, that is by the members, or by a board resolution. So because these people act as the company, so it then automatically means that for the primary organs, on the one hand we have the what, the members in general meeting, and on the other hand we have the board of directors. We looked at the corporate governance architecture yesterday. So these members in general meeting, The board of directors, when they act in compliance with the law, when they act in what? In compliance with the law, whatever it is that they do, it is the company that has done it. It is the company that has what? Done it. So what it means is that if you are dealing with what you maybe you want to enter into a transaction or so with a particular company and a board resolution was passed, it means that you are dealing with the company what? Directly. So in this case, you need not to be worried about, oh, whether who you are dealing with has the authority to act on behalf of the company. No, this is the company. You are dealing with the company. So I don't want you to start isolating the company as one spirit somewhere, and then the board of directors and the members in general meeting, because they are the human beings, you now see them as being authorized by that spirit to be acting. No, they are the company. They are the company. When they act in the way and manner prescribed by the law. So that is also why in the last class yesterday I also mentioned that just because a group of shareholders decide to just meet and take a particular decision does not mean that that's the decision of the company. No. Yes, they are shareholders, they are members. But the question is, did they take that decision in general meeting? The question is, the general meeting itself, was it convened in accordance with it? Did they comply with the law? It is when they comply with the law as to how these members should take this decision, that is now when you can say the company has taken that word decision. And the same thing goes for what? For the board of directors. So when you hear the word company, the word company essentially refers to the members in general meeting and the board of directors. So when you see company must do something in the act or any other law, basically it means that that decision is to be taken either by the members in general meeting or the what? The board of directors. And at times, the act may also now be specific rather than saying company. You can just say directors shall do something, or something is to be done at the members in general meeting. Whether it says the board of directors should do that thing, or it should be done by way of a resolution passed at what? The general meeting. It's basically still the same thing as saying the company must do something. What the act has done by is either referring to what? To the board or the members, is that instead of saying company, because when you say company, it means it refers to either the members in general meeting or the board of directors. So it means that you still have to take a step further. You know that, okay, it's the company that will do this thing, and the company here refers to either the MGM or the BOD. But you need to now take a step further to now know which of these two bodies is now the one to take that particular decision. Because that is also another issue. Where the company is to do something, you need to also be sure that it is not a decision that will be taken by the members in general meeting and it is the board that is not taking it, and vice versa. But when the act say the director shall do something, it has made it what? Easier for you, because you just know that it's the company that is doing that thing. But because the company is either the members in general meeting or the board of directors, the act has been now specific to say is the board, or to say is what? Is the members in general meeting. But you see that it is not what? As clear as what? In all circumstances in what? In the act, because there are sometimes that the act will simply say company, and then you start wondering, because you know that the company refers to MGM BOD, so you start wondering between the MGM or the BOD, which is what? Which is the company? Are we following so far, please? All right. So now, what it also now means is that once we have this what? MGM and the what? And the BOD. And remember, when we looked at the corporate governance architecture, the BOD here, remember the division that we made: supervisory board, the executive board, that is the management, right? Remember the role of what? The committees, all of them still under what? The BOD. As we go further, when we look at board of directors as a topic on its own, you will now see how these decisions are taken. But at least what you are concerned with here is that however it is that decisions are being taken here, at the end of the day, if it is the board that has the authority, it shall be the board that is taking that decision. And if it is the members in general meeting, it shall be the members in general meeting that is taking that decision. So this here is the company. So if I ask you, who is the company? So by now, stop thinking of because the company is an artificial entity, and you make it so much difficult for you to comprehend how a company exists, and a company can do things that human beings can do, because the company is necessarily a group of what? A group of human beings that are acting in a particular manner prescribed by the law. So these are the now for the secondary organs. The secondary organs, yes, what they do to also impact the company, either positively or negatively. Yeah, the company can also be held liable, the company can be responsible, or the company can take benefit of the actions of these people too. But the difference here is that, BOD and MGM is more or less synonymous with when you deal with the Salama directly. Salama is the owner of the what of the business, right? Or Salama is the one that you want to come and render a particular service to you. That is what you have here. But when you are not dealing with somebody that is acting on behalf of Salama, so you are assuming or you believe that that person has the authority of Salama. So such that even though you deal with that person, if there's any issue, you are not going to sue that person or have any issue with that person. You are going to have issue with what? With Salama. In fact, when you are entering into a contract and it's signed by that person, so as far as you are concerned, and in the eyes of the law, it is Salama that was signing this. That is the same thing here. So for the secondary organs, it is the secondary organs are not the company. But the reason why their actions can also impact the company, that is, the company can be held liable for their own action. The reason is that the law attributes their actions to the company. So what does that mean? If the company is the primary organs, it means that for the secondary organs, whatever it is that they do, right, it is more or less taken to have been done by the primary organs. So if the primary organ is the company, it means whatever it is that they do, it is taken to have been done by the what? By the company. And I told you, the only way that can happen is to use the doctrine of attribution. And what is the doctrine of attribution? Is either agency or vicarious liability. So what it translates into is that for the secondary organs, for them to act and for their action to be attributed to the company, there must necessarily be what? Authorization. So what connects the primary organ to the secondary organ is what? Authority. It's authority. Which means these people or these persons must have acted as the agent of the primary organs. It must have been that either the members in general meeting authorize what? This person or these people, or the board of directors, they authorize what? These people. And they said you can go and what? You can go and act. So it essentially means that what? The company has what? Has authorized these people, or is in the nature of vicarious liability. So that is for the secondary organ. So they can bring about liability to the company on the basis of attribution. So you must prove authority. Either you are proving actual authority. You are proving ostensible authority. Do you understand what I'm saying? So or apparent authority, but or implied authority. You must be able to show that they have the authority of the primary organs. So that's why you cannot say they have the authority of the company. And since they acted within the confines of their authority, the company has acted through them, and he will act through or another act for himself. So you treat the company as the principal. So it's basically more like the primary organs will serve as the principal of the secondary organs. Of course, that is when you are looking at it from the angle of agency. And if it's from the angle of vicarious liability, you are just showing that that person that is the secondary organ is in an employment relationship with what? With the primary organ. So that is the reason you see that you can sue a company, for example, simply because of what an employee did. Yeah. Maybe it's the receptionist of the company that has done something, and then you are suing the company. Now, the question will be, why are you suing the company? If the receptionist did something, why are you not suing the receptionist? Why the company? Now, you want to say that, well, whatever it is that the receptionist did, it was done to you by the company. So, and in that case, the question will now be, how so? Because the receptionist is not the company. The receptionist is not the company, because the receptionist is neither the members in general meeting nor the board of directors. So you are left with either showing that the receptionist is acting on the agency of what? Of the primary organ. Now, for the receptionist, remember that when we looked at the BOD, we said the BOD has the supervisory board and the what? The executive board. And we said the executive board or the management, they are really the ones that handle the daily operations or day-to-day operation and administration of the company. So what that translates into is that it's going to be the management under the leadership of the chief executive officer or the managing director that would have employed that receptionist. So it automatically means somehow it is the board that has employed. So the company employed what? That's why we said the company can what? Employ a person. So when we say the company can employ a person, we are talking about what? The management employing the receptionist. So the question will now be, if the management employed the receptionist, did the management, as part of the board, authorize what? The receptionist to do whatever it is that the receptionist has done? So maybe it's part of the terms of reference or the employment contract. That's part of what he or she can do. So you can look at whether the authority given to do that particular thing is express, right? Or maybe it's something that can be implied, right? Or maybe this person does not even have the authority. But this same receptionist has been doing the same thing over and over again to the knowledge of the management, and to a way that it creates the impression to outsiders that this receptionist has the authority, even though the receptionist does not have the authority. In that case, you can say that the company can be held liable because that receptionist has what? An ostensible authority, that is, or apparent authority. So you can, that means you are going by agency. But if you cannot go by agency, you can just say, well, there is an employment relationship between this person, the receptionist, and the company. How? Now, the management employed what? Employed her. I don't say, but that's the management. Well, the management is part of the board of directors, right? And the board of directors is what is the company. So essentially, the company employed her. And whatever it is that she did, you want to show that what she did it what in the course of her employment. So you may want to go by way of vicarious, liability. So this basically is what, speaking of the organs of corporate administration, is all about. Are we clear also to this extent? Sorry, what did you say, Esther? Yes, I'm correct. All right. Now, let's now go by section 87 of CAMA. Section 87 of CAMA. And that is the reason yesterday I told you are supposed to come with what? With your CAMA. If you go by way of section 87, sub 1 of CAMA, what it says a company shall act through its members in general meeting. So how is the company acting? CAMA says a company shall act through its what? Members in general meeting. You don't worry about who the members in general meeting are for now. That is a separate topic what on its own. We are going to look at meeting. So it says a company shall act through its members in general meeting, or its board of directors. So MGM, BOD, these are the primary organs. They act as what? As the company. So if you need an authority for this explanation I made earlier about primary organs, about the MGM and BOD constituting the primary organs, yeah. Of course, by now you should already know that this BOD would then include committees, include what? Management, right? So the authority is 87 sub it's a trite principle that has simply been codified into our law, to our statute. So it says the company shall act through its members in general meeting or its board of directors. But when you also now look at that same section 87 sub 1, when you look at it further, you see that there is also now what? Another or, which is a big or. So it means that it's either you are acting through the members in general meeting or the board of directors, or that company is also acting through who? Say through officers or officers, agents, through officers, agents appointed by, this is very important, appointed by, either it is that these officers or agents are being appointed by, or under authority. Either you are appointing them or under authority derived from, under authority derived from the members in general meeting or the board of directors. Is this not clear? This is clear. It's not enough that the officers or agents have acted. If the officers or agents act, and that's all that there is to it, that they acted, then the company has not acted through them. It is when the officers or agents act, officers, agents that have been appointed by, either it is the MGM or the BOD that is appointing these officers or agents, or they have been authorized by what? The MGM or BOD. And that was what I was explaining, that the secondary organs, you can only hold the company liable when the MGM or the BOD have either what? Authorized what? This particular persons. Is that understood, please? Is that understood, though? Mm-hmm. And in fact, after After we have identified these organs of corporate administration, the next topic we are going to look at is liability for the act of the company. And in that case, you see how I would now explain elaborately on how the actions of these people can hold the can bring liability to the company. But in any event, just as a way of jumping what's the gun, if you look at section 90 sub 3, section 90 sub 3 of CAMA, and my assumption is that you are also with your act. You look at section 90 sub 3 of CAMA, it says nothing in this section, that is the section 90, not 87. No, I'm still coming back to 87. I've used 87 to show you that part of agency, authority, right? Appointed authority, right? Now, if you look at section 90 sub 3, it says nothing in this section, that is section 90. So what is section 90 about? Act of officers or agents. Section 19 delineates how the actions of officers or agents that have been mentioned here, how their actions can bring about liability to the company. And you see that what the whole of paragraph A, B, and subsection 2 is talking about how their actions based on authority, the different types of authority can bring about liability. So that is just on the agency part. But when you look at 90 something, it says nothing in this section shall derogate from the vicarious liability. So it's basically saying that just simply because we have shown you in this section 90 sub 1 and sub 2 that the company can be liable on the basis of agency, it does not mean that what the company cannot also be liable from vicarious liability. So it says nothing in this section shall derogate from the vicarious liability of the company for the act of its servants while acting within the scope of their employment. So which means that another way for the secondary organs to bring about liability to the company is through vicarious liability. So that's why I explained the doctrine of attribution to take two forms: agency or what, vicarious liability. So this further consolidates what we have in section 87 sub 1. So that way the secondary organs will make the company liable on the basis of agency because they have acted as the agent of the primary organs, or because they have been employed, they are in employment of what, of the primary organs. And the primary organs here refer to the company. So in a way, you can substitute primary organs and what, use what, company, and you'll be correct. Are we following so far, please? Hello, are you guys there?
Yes, I said yes.
All right. Sorry, please give me a minute. All right. So when you look at it, 7 sub 1, it basically tells you lines of what, of authority, and then even though the act has not said primary organs, secondary organs, but you as students of a really conduct, you should already know essentially what 87 sub 1 is, what is talking about. Now, when you now look at 87 sub 2. No, no, no. Okay, before we look at it, 7 sub 2, I think there is a need to raise some topical issues on what we have discussed so far. Now, what are the topical issues that can arise from it? Now, the idea is that, yes, for these primary organs, yeah, and the primary organs here being the company, those that act as what? As the company, yeah. We already said, Kama, and Kama already said it, that they constitute two bodies. On the one hand is the MGM, and then on the other hand is the what? Is the BOD. Now, their existence is not what? Not for decoration. A minute. Their, what's it called? Their existence is not for what? For decoration. Yeah. So the, sorry, please, a minute. Can this, All right, all right, all right. So, as I was saying, their existence is not for decoration. Now, you know that for the company to act, the company act through these what entities, these two bodies, and the idea is that it means that some decisions that are corporate decisions, that is decisions of the company, are either to be taken by the members in general meeting, that is the members holding or convening a general meeting, or by the board of directors, the directors acting collectively as what, as the board, right? Now, the question now is, what are those decisions that are to be made by the members in general meeting? What are those decisions that are to be made by what, the board of directors? The reason being that if, for example, now, if you go to section 341, let's just look at section 341. Let's take it as an example to just somewhat highlight this topical issue for you. Now, if you go by section 341 of comma, and I hope, just as I'm searching for that section, I hope you're also searching for it wherever it is that you are. Now, when you look at section 341, of comma, what do you see there? It says that subject to the provisions of this act, where an irregularity is made in the course of a company's affairs, or any wrong is done to the company, only the company can sue to remedy that wrong, and only the company can ratify the regular conduct. Let's just take the part of suing. This 341 says only the company all right. So, and if you look at what your 341, what did you see there? It basically says the company. So, which means in provisions like what 341, the act has not what helped us. The drafters have not helped us to determine who the company is. So the question now is, does it mean that when there is a wrong against the company today, the board can just say, we are the ones to take this one? Or does it, and then tomorrow, now say, don't worry, members, when there is another wrong, you people will be the one to take what decision? And there are times that the members in general meeting, because they are the investors, they are the ones that created the company, conceived the idea of the company, or maybe you join the company later on, but the idea is that they have stakes, they have equity in the company. So factually, they are the owners of the company and its business. Well, not necessarily that they are the owners of the business of the company because of the legal theory of corporate personality. The company owns what? Its business. But the idea is that they have stake in that company. So, and remember, the board of directors, as you shall come to learn, you see, they are typically appointed by the members in general meeting to go and manage the business and direct the business of the company. So there are times that they feel that they have an authority, like I'm the owner of this business, I appoint you to help me, you are just a manager, you are an employee to me. So when I give you instructions, when I tell you what to do, you are meant to what? To obey me, to comply with my instructions. So there are times that they might feel that, in a particular circumstance, they are the ones that are supposed to take that particular decision. Or they might feel that, sorry, a minute. Do you understand what I'm saying? So, in cases like this, let's also look at another section. Let's look at section 114 of the Act. Let's look at section 114 of the Act. 114 of the Act. Now, which is prior to what? To close register. It says a company may, on giving notice by advertisement in a daily newspaper, circulating in the district in which the registered office of the company is situated, close the register of members. The idea is that here is basically saying that a company may close the register of members after the company has issued what? Advertisement. The question is, who is the company here? Who closes what? The register of members. Is it the board that decides that? Or is it what? The MGM? Who issues the advertisement? Because the advertisement will not issue itself. You have to meet a newspaper publication. You enter into a transaction. You pay. Who does all these things? Is it a decision taken by the what? The MGM? Or is it a decision taken by the board? There are times that the board will be the one to carry out an act. But that is after the MGM has decided it. They have approved it. And then they have now gone ahead to now authorize the board. So the idea here is necessarily the decision making. Who gets to make that decision? It is not what? Clear, because it says the company. And you know that the company can either be the members in general meeting or the board of directors. So these are, the topical issues. And it means that as part of learning this course, particularly corporate governance, is that you are also meant to now learn how companies develop their corporate governance framework, so that the MGM will know what decisions or actions that they can take, and the board of directors will know what decisions or actions that they can take. But when you are developing your corporate governance architecture, you must also do so in line with what? In line with the law. And what does that mean? The idea is that you must do so in line with CAMA, because there are certain circumstances where CAMA would have been specific, where CAMA would have said, so decision is to be taken by the directors. Let's look at section 314. And please, I'm not citing these sections for you just for the sake of these sections. I'm using this section to explain every point or principle. And that is what you are also expected to do in your exam. So don't just stay here. Already David has mentioned the section. As I've mentioned this section, you're writing them down, you're checking the acts, and then you know exactly what the section has said. And the point I'm trying to drive home with this section. So when you look at section 314 of CAMA, which you're already aware of, right? It's basically talking about saying the limited liability company, the liability of blah 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 may, if so provided by the memorandum, be unlimited. Now, when you look at this, it says if so provided by the memo. So what if it is not provided by the memo? Who gets to make their liability to be unlimited? Well, it is the people that can amend the memo. And who can amend the memo? Of course, by reason of sections 50 and 51. The memo can only be amended by way of a special resolution. Now, when you hear special resolution, it doesn't still say whether it is the board or the members in general meeting, because it just says special resolution. Yes, that should not lead you to now checking or determining what constitutes or amounts to special resolution. And on this, I invite you to look at section 259 of the Act. Section 58 rather. 259 is on written resolution. Section 258, the heading there says resolutions. Now, when you look at sub 1, it says a resolution is an ordinary resolution. 258 sub 1 is talking about ordinary resolution. It says a resolution is an ordinary resolution when it has been passed by a simple majority of votes cast by members of the company as being entitled to do so, vote in person or by proxy at a general meeting. So it means that an ordinary resolution is a resolution that can only be passed at general meeting. So when you hear that something is to be done by way of an ordinary resolution, it means that the Act is telling you that that decision is to be taken by the members in general meeting. It doesn't necessarily have to say general meeting all the time, because an ordinary resolution is a resolution that is passed at general meeting by the members. So all those things relating to, say, increase of share capital that you treated in last semester, reduction of share capital, you understand what I'm saying? They are resolutions, right? And then you see that's what that said that. Now, when you look at section 258 sub 2, it says a resolution is a special resolution when it has been passed by at least 3/4 of the votes cast by who? Members of the company. Vote in person or by proxy at a general meeting. So it's still talking about what? Members voting at what? General meeting. Still members in general meeting. So when it says something is to be done by ordinary or special resolution, it's also indirectly saying that it should be done by the members in what? General meeting. So in cases like this, you see that the act has already noted who should what? Should take that decision. So in a situation where you now want to draft your own internal document to be able to delineate the powers of the MGM and the board, because you want clarity and you don't want what? Conflict. And you don't also want a situation where you are just proliferating what? Powers, right? Or duplicating power. You have to bear karma in mind. So typically, it's the Articles of Association that is used for that purpose. The Articles of Association that is used to delineate the powers,